In a recent and intensifying dispute, Singapore's civil society group, the Transformative Justice Collective, TJC, has strongly rejected the government's accusations of spreading falsehoods following the issuance of two Protection from Online Falsehoods and Manipulation Act, POFMA Correction Directions, CDs, in less than a week. While TJC complied with these POFMA CDs, the group remains firm in its stance that the government has fundamentally mischaracterized their social media posts regarding the executions of two Singaporean death row prisoners. The TJC has voiced that the government's correction directions only serve to confirm their observations. Both of the executed prisoners had pending civil applications, and one also had an additional criminal review application at the time their execution notices were issued. Notably, these critical facts were absent from the Central Narcotics Bureau's CNB official statements regarding the executions carried out on the 2nd and the 7th of August 2024. The Ministry of Home Affairs, MHA, directed the POFMA office on the 8th and the 11th of August to issue correction directions to TJC's posts, accusing the group of falsely claiming that the executions were scheduled without regard for due legal process, and that the state uses capital punishment to arbitrarily decide whether people live or die. Despite complying with these directives, TJC remains critical, particularly of the timing and procedures surrounding the execution notices. In a statement released on August 12, TJC expressed deep concern over the timing of the execution notice for a 45-year-old inmate executed on August 2. The group questioned whether the president signed the execution order before the inmate's review application, heard on July 26 and dismissed on July 30, had been fully adjudicated in court. TJC argues that regardless of whether this review application was materially similar to previous ones, it is not within the government's purview to replace the court's role with their own judgment on the likely outcome of such legal proceedings. TJC also highlighted that the Court of Appeal's ruling on August 2, which stated that the pending civil appeal would not affect the prisoner's conviction or sentence, came after the issuance of the execution notice. Yet, the prisoner was executed on the same day. Similarly, they noted that the second prisoner had withdrawn from a civil application, but this did not change the fact that he received an execution notice while still involved in ongoing legal proceedings. TJC argues that issuing execution notices while legal proceedings are still active is a violation of due process and an affront to justice. TJC further recounted a harrowing instance from August 2022, where 24 death row prisoners were forced to represent themselves in court via Zoom, without legal representation, under a tight timeline. In one case, a civil application was filed on August 1, with submissions due by 6 p.m. the next day. The High Court struck down the application on August 3, and the Court of Appeal dismissed the appeal late on August 4. The prisoner was then executed early the following morning. TJC's critique extends to multiple cases from April and May 2024, where several execution notices were issued while prisoners were still challenging the constitutionality of the blanket ban on legal aid in post-appeal applications. While some executions were stayed at the last minute, TJC argues that prisoners should not be placed in situations where they are compelled to file additional applications merely to prolong their lives. In their concluding remarks, TJC pointedly questioned whether the state views the death penalty as an administrative formality, devoid of genuine concern for human lives. They emphasized the emotional and psychological toll that these processes inflict on death row prisoners and their families. TJC reiterated their criticism of the Post-Appeal Applications in Capital Cases Act, PACC, arguing that it infringes on the fundamental rights of those on death row. Moreover, they condemned what they termed the weaponization of POFMA to stifle dissenting opinions, warning that such misuse undermines freedom of expression in Singapore and is part of a broader trend of suppressing opposing voices. In a biting conclusion, TJC sarcastically suggested that Home Minister K. Shanmugam watch a YouTube video titled Fact and Opinion for Kids, implying that the minister struggles to distinguish between dissenting opinions and factual statements. What do you think about the use of POFMA in this case? Do you believe it's a tool for maintaining truth or a weapon against dissent? Let us know your thoughts in the comments below. Don't forget to like, share, and subscribe to our channel, 2230. For more in-depth news coverage and analysis.